Looking for a fast-charging, ultra-responsive stylus for your iPad? Meet the 2X Fast Charge Active Stylus Pen, designed for 2018 to 2025 Apple iPads. Take your creativity and productivity to the next level. Click the link in the video description to shop now on Amazon.
Welcome to Katy's Kingdom, where we dive into the fascinating world of trademarks and trademarks. Today, we're going to explore a unique case that's got everyone talking: Katy Perry v. Katy Perry. Imagine this: two women with the same name, but one is an international pop sensation, while the other is an Australian fashion designer trying to build her brand from scratch. Sounds like a recipe for disaster, right? But in this case, it gets even more complicated. Katy Taylor, the Australian fashion designer, has been using the name Katy Perry since 2006, long before Katy Perry's rise to fame. She registered the name as a trademark and has been selling clothes under that brand ever since. However, when Katy Perry decided to expand her merchandise line, she couldn't just use the name Katy Perry. That would be confusing for consumers. So she registered her own version of the name, Katy Perry. But here's the thing. It turns out that using a similar name isn't just about avoiding confusion, it's also about reputation. The Australian courts have ruled that if you're known for something in one space, you can't just waltz into another space with your trademark. This brings us to Section 60 of the Trademarks Act, a law that deals with trademarks that are similar to other trademarks with an established reputation in Australia. Sounds simple, but trust me, it's not. The full court has interpreted this section to be incredibly broad, giving famous people and large corporations a lot of power. But is that fair? My friend, Jason Sprague, a trademark lawyer, thinks not. He believes the courts are going too far by giving protection to big brands in spaces where they're not even using their mark. And he's not alone. Many experts think the full court's interpretation of Section 60 is too broad and undermines the protection that should be provided to everyone. So, what does this mean for the little guy? Well, it means that if you're trying to build your brand from scratch and you can't even use a similar name due to reputation concerns, you might be out of luck. But here's the thing. Jason believes that people are more aware these days when it comes to trademark disputes. They know that using a similar name isn't just about confusing consumers, it's also about avoiding deception. And that's what Section 88(2)(c) is all about: whether use of a trademark is likely to deceive or cause confusion. So, while the full court's interpretation might seem powerful, Jason thinks people are more attuned to spotting those kinds of tricks. So, what's next? The High Court will be required to examine some difficult issues that it has not examined before. Will they confirm existing law and practice, or take a different approach? Only time will tell. But one thing is for sure: this case is going to make a big impact on our understanding of reputation and the role of discretion in cancellation proceedings. That's all for today, folks. Thanks for joining me on Katy's Kingdom. If you want more trademark talk, be sure to subscribe and hit that notification bell. Until next time, stay trademarked.